Hi everyone, good morning, good afternoon, and good evening depending on your time zone. We are back again to evaluate the proceedings and what is going on and the trial of Nnamdi Kanu and the federal government headed by Justice Abubakar Malami. Before we continue, we will ask you to subscribe to this channel, share our videos, and give us thumb up as well as leave your comments. Thank you very much. And we are going to look at the laws beyond Nigerian territory and what the topic has emphasized. Once again, Nigeria is a member of international communities, especially the United Nations, and also signatory to most of the treaties that govern the United Nations. It appears from all indications and from the sources that Nigerian government does not understand what international law is all about. And that is why the Justice Minister is manipulating on behalf of the government or collective manipulation of the Fulani ethnic cabals that wants to punish Nnamdi Kanu over his refusal to allow the bandits, the ISWAPs, the Boko Harams, Fulani Hillsmen, and other activities from this group to take place in southeastern Nigeria, despite every effort by the eastern governors to ensure such activities are allowed into the southeastern states of Nigeria. Well, it is stated that governments sometimes fail to adequately uphold their human rights commitment. This is one of those problems the Nigerian government is having. But however, impunity for crimes against international law means that torture, extraordinary killings by any means by the government sponsored or armed forces, even in armed conflicts, that has failed to investigate the atrocities of their security agencies or other crimes committed by the above-mentioned Fulani Hillsmen, ISWAPs, bandits, Boko Haram, and other Fulani criminals within the Nigerian state, especially in southeastern state of Nigeria. This is the main reason why the United Nations and the law operators in the United Nations criminal courts and tribunals stated that dictatorships violate human rights and refuse to uphold the commitment of the nation to their signatories and promise to abide by the rules of United Nations. Nigerian government has forgotten that Nnamdi's case lies between national and international laws. Hence, every proceedings in this case is properly monitored, not only by the local but also international watchers. Although one would understand that the Nigerian government is putting pressure on the Binta Nyako High Court to ensure that they use her to put judgment on Nnamdi Kanu. But however, the Justice Binta Nyako has always tried to avoid some certain pressure from the leadership of President Muhammadu Buhari. She has avoided, in most cases, the pressure, and they are still putting pressure on her. It is unfortunate that after the judgment of Court of Appeal on release and discharge of Nnamdi Kanu, which has been made known to everyone, and the international community has understood this and has welcomed it. But they are still not satisfied with this. Everyone will also understand that they have fear that if they release Nnamdi Kanu, that it might be difficult for them to have election, especially in the southern part of Nigeria. Well, this has no relationship between judgment of the court and what is going to happen after his discharge. In this discharge, the court also in Umuahia has requested that they take him back to where they picked him up, and the Court of Appeal has stated categorically clear that he is discharged and acquitted, and they don't have jurisdiction over what happened outside Nigeria. That brings us to what jurisdiction is all about. Jurisdiction is the power of a court to hear and decide a case. In criminal law, it means power to prosecute, impose, or dispense judgment and punishment where guilty is found. There are different types of jurisdiction in criminal case. Especially, this has to be divided into state jurisdiction, federal jurisdiction, and the universal jurisdiction for purpose of understanding and also learning. The state jurisdiction shows that the state has power over crimes committed within a state or state borders, or in some cases 3 to 4 kilometers of east coastal lines. It is the state courts that can prosecute in this very area should crimes be committed within this very border of definition. On the federal jurisdiction, this occurs in federal zones, federal establishments, international areas like international waters, airspace, and areas that are controlled by the federal government outside the state-owned territories. However, when cases are transferred to federal territories or federal appeal courts, that is entirely a different issue. However, without jurisdiction, no court has legal authority to address any substantive case. That is without jurisdiction. Without jurisdiction, prosecutor or court's decision will be null and void, and eventually will not be enforced by the court or any authority. Without jurisdiction, court has no authority to act on any further case brought before it. Without jurisdiction, eventually, an appeal court cannot do anything rather to dismiss the appeal. Any appeal brought before the appeal court whereby it has no jurisdiction. That means the only action it can take is to dismiss the appeal and will not entertain such case any longer. That is what it means without jurisdiction. This means in general that crimes committed within the federal territories or controlled zones are treated by the federal courts, directly by the federal court, I repeat. Otherwise, crimes committed within the states are treated by courts within that state. Then there is also what is called universal jurisdiction. The principle of universal jurisdiction provides for a state jurisdiction over crimes against international laws, even when the crimes did not occur on the state territory. It can also be treated outside the nation's territory where the crime is committed. That is why it is universal. It concerns international law. The principle allows also national courts in the third countries to address international crimes occurring abroad. The aim is to hold the perpetrators criminally liable and to prevent further impunity from the perpetrators. The question comes as what gives rise to universal jurisdiction of international law? To determine which crimes give rise to universal jurisdiction under international law, one has to look at the international treaties such as the United Nations Convention Against Torture or the Geneva Convention for War Crimes and the General Customs of States, customary international law, under which genocide and the crimes against humanity are considered crimes of universal jurisdiction. Like stated earlier, it includes torture, genocide, crimes against humanity, and other crimes considered under international law by the United Nations. On the process of extradition under international law, when the accused is not in the prosecuting state, it will be necessary to obtain his or her custody. The traditional way to do so is to request his or her extradition. There are other alternatives, however, such as the deportation of an alien to the state of his nationality. Therefore, by international standard, extradition is the procedure by which one state asks another to surrender someone that the requesting state claims a right to prosecute. In Nnamdi's case, this is what the government of Nigeria did not do. But according to Malami, he stated that he does not know that such law applies. However, in doing so, the acts alleged must be criminal in both the requesting and the requested state. Most extradition treaties will list the specific crimes for which extradition will be provided. This Nigeria did not do, neither did Kenya government do so before the illegal rendition. Normally, the requesting state must present a prima facie case against the suspect before he can be extradited. Again, this was not presented by Nigerian government to Kenyan authority. On political offenses, most states will not extradite a suspect for a political offense. From sources close to Massive Human Rights and Freedom Initiative on its inquiries shows that the failure of Nigerian government to carry out the necessary inquiries, to carry out the necessary legal procedures has put it into a very tight position. And again, that the judge or judges of both High Court and Federal High Court has given judgment, and the government of Muhammadu Buhari and the Justice Minister, Abubakar Malami, appeared to have been rejecting the judgment of the High Courts and Appeal Courts and wanted to introduce a new system whereby he wants to carry out the program or the project laid down earlier before the abduction and the rendition of Nnamdi Kanu. The international community is taking it on board, noting now that the President of Nigeria does not understand the United Nations legal powers of customary international court, and also that the Human Rights Council and its reports to release Nnamdi Kanu is still standing. And this will, at the end of the day, if not carried out, will invoke the universal jurisdiction and the application of International Criminal Court, already pending, waiting for the government of Buhari to do the justice and release Nnamdi Kanu and allow Nigerian government to proceed if they dare need that to go on. International community has now enough evidence to show that through the legal team of Nnamdi Kanu, through various speakers at international television stations and also the newspapers, the Buhari government and the Malami and their sponsors may not understand that what constitutes further evidence in international law are what people say after each judgment, after each case, and the collection of media reports. These will constitute further evidence to be used against Malami and their group when any of these laws are invoked. They should remember Hussein Habre of Chad and all others who have behaved in a manner similar to what the government of Buhari and his cliques are displaying. The question is it not wise for the president and his Justice Ministry department to release Nnamdi Kanu and have freedom from the International Criminal Court or Universal International Criminal Law? Which one is better? To keep Nnamdi Kanu and put themselves back as well. The rights of individuals are granted, and Nnamdi Kanu has been given his right to freedom, freedom of speech, freedom of association as a freed man. Why is the government of Buhari not adhering to the judgment of his own court, as well as the judgment of international community or advice of international human rights group? What is happening? what is going on. With this, we ask you to judge by yourself and put down what you have as your own personal judgment, or reserve it to yourself or discuss with your friends and well-wishers. With this, we come to the end of this very program. We ask you to subscribe, share our videos, leave your comment, press the notification bell for all these videos to come to you, and also give us a thumb up. That is very important also. Thank you very much for listening. God bless you all. Bye.